Hi, everybody. We have a special episode here today. We have Kathy InDieZoNe visiting us, and we are going to talk about the jury questionnaire and jury selection. That is going to be the topic for tomorrow, but it'll be under seal. Hi, Kathy. Welcome.
Hey, Audrey, how are you?
Doing good. Doing
Oh,
good.
who is that you have in the avatar right there?
On the screen here,
Yeah.
you mean Brett Payne, part-time marine biologist?
Brett Payne, what is his full-time job though?
Sometimes he can't remember, but usually it's a marine biologist.
Alleged.
Allegedly. Hello, Erica. Welcome. So good to see you.
Now there's something happening tomorrow. Everyone's focus is taken off of because they're looking at the eliminate motions and all of the evidence that was now produced. Audrey, what is that?
That is the hearing for the jury questionnaire and jury selection.
Oh my goodness, you have the Judge Hippler order up here.
Yes, we do.
Could we go down that just a little bit? Okay, it says all other orders are vacated. So live voir dire shall commence on July 30th. What does this mean, Audrey?
So that's when they start the jury selection.
Is that something you would like to
July
see?
30th. Oh, yeah, absolutely. That'll
Why?
be so
Why?
interesting to see how they ask these juries questions, what kind of juries are there actually in Ada County, and just this whole process is really important so we can see our U.S. legal system in action, how it works.
Some people think this is no big deal.
This could make or break the entire case, depending what peers. You're entitled to a jury of your peers, and it's a very much a part of the process and the trial, and to be able to see them chosen and to ensure fairness.
Okay, so it says here voir dire starts July 30th, 9 a.m. That's when all of the citizens of Ada County who are called for jury selection in this case go to the courthouse. Is this closed to the public right now?
I don't know if we know yet. Do you know, Kathy?
It doesn't look like it to me. Look at voir dire. Do you see closed to the public here?
No.
No, not at all. So this should be open, right?
Should be.
Okay. Go, Audrey, could we go down next page, please? Okay. A little more.
Okay, we're past this date, right? Should we go down further?
Right. Go ahead. Okay. Look at that D trial materials, proposed jury questionnaires. When is that filed?
It was filed under seal March 24, 2025. And objections are due March 31st, 2025. A sealed closed hearing on the proposed jury questionnaires will be held on April 16th, 2025.
Okay, that's tomorrow, right? March 24th?
Oh my gosh, it is. Look at that.
Yeah. No big deal, right?
So
No big. So important to the
Wow.
public. Everyone's looking at Eliminate right now, but you. No one else is looking at this. So we have the proposed jury questionnaires going to Judge Hippler tomorrow under seal and a secret hearing.
These are so important. Yeah. Oh, secret
Look
hearing.
at that.
Oh, hi, Diane. Welcome. Good to see you. Yes, tomorrow, Erica.
So why does this concern you? You know, these are the questionnaires that will be disseminated to the future members of Ada County who are called to the courthouse to fill out. And we don't know when this is happening because it's redacted. Audrey, go back to page 1, please.
Alrighty.
Please. Because we want to know, as the public, when is this jury questionnaire being administered?
Oh, look here. It's the first one under A.
And
Jury questionnaires will be administered approximately redacted, but in
we
2025. But
why is this all secret? Why is this all secret?
very strange.
So they're going to submit the jury questionnaires to Judge Hippler tomorrow under seal. Public can't read it. There's going to be a hearing on April 16th regarding the final version of this jury questionnaire. Secret under seal hearing. And now the questionnaires will be administered. That means someone from the court is going to pass out whatever Hippler, the state, and the defense decide is going to be this final questionnaire to the members of the future jury panel. We don't know when it's going to happen, right? The only part of this order that's redacted has to do with the jury questionnaire.
This is so important because I know that there have been other trials where these I think I just got that confused with jury instructions. But even so, jury instructions are very important too because they need to be understandable to the actual jurors and they need to be functional as well to actually make a.
Before we get there,
Yeah.
the jurors have to be selected.
Mm-hmm.
Why this secrecy?
I don't know if they're trying to protect identities or if this is just more of the suspicious things that they've been doing under seal. I'm not sure. What do you think, Kathy?
I don't know because voir dire is supposed to be open to the public. And I think what's going to happen is voir dire will be sealed. We will not be able to see what questions are being asked, how they are responded to. And the members of the jury are so crucial. They are looking to put this defendant, whether you feel he's guilty or not, in front of a firing squad. Do we, the public, not have the opportunity to know everything regarding how they are going to select this jury? What questions will be asked of them? What questions will not be asked of them? We have 4 young people who were taken in the most horrible way imaginable. Don't we, as the public, have a responsibility to know who is being charged with this crime, who is not being charged with this crime, and what it is that's being told to the future jury regarding the only person who has been charged? That's it.
That's a great way to say it. That made my stomach drop when you said it, but that's 100% what's happening here. And if I were a taxpayer in Idaho, I would want to make sure that, my money is going to the right thing. And I would want to know what those things are.
Right. So we don't know what this evidence is yet. We've gotten bits and pieces. I'm going to go on the record here. I feel that 911 call is authentic. I feel it was proper, not staged. But by the same token, how did they arrive at Brian C. Koberger above anyone else? I don't know.
I don't know either. That's the question.
Right. So we have a poll going on right now on my YouTube channel, and it's like 80% feel that he is. Thank you. 80% feel not guilty if they were to vote today. Audrey, what do you think about that?
That's incredible, knowing how we started out. If you
Right.
have been watching this case since the beginning, or you came in however along the way.
Right.
Yeah, and even in light of the possible purchase of the knife on Amazon, even through all that is incredible. I have put the link in the chat if anybody does want to vote for this wonderful poll that Kathy has here.
Audrey, what do you think of the autism diagnosis?
I think that is more of a legal formality than it is actually for an appeal or anything else that has to do with the types of emotions that could come with the public. Because I do know that there's a trend now, because there was a recent court case. I'll have to bring that up and put it in the description, but a man was found guilty of the crime that he committed. However, he did have autism. So during the sentencing stage, they decided, or I can't remember if they reversed it later after that he had been sentenced to death. But because he had autism, they reversed that. And that's not the only one. There was another state Supreme Court who also did that. So there's a trend in the states now that this is happening for people specifically with disabilities, and autism is considered a disability. And so I think Ann Taylor, this is her field, so she can feel when the trends, the climate changes for these different type of legal arguments. And I think that, that this is one of those things where she is just complying with where the trend is going for that type of thing when it comes to sentencing. And so, hello, Preston B., welcome. How about you, Kathy?
Well, let's go back to the case in chief, because this is what will happen August 11th or sooner if Judge Hippler amends the trial order. You're going to see the defense with Mr. Koberger at the table, the state with all of prosecutors and Brett Payne at the table. This crime allegedly happened between 4:07 a.m. and 4:20 a.m. with suspect vehicle 1 seen speeding out of the neighborhood at 4:20 a.m. That means that the perpetrator had to leave the property before 420 to be seen speeding out of the neighborhood at 420, maybe at 419. So now we have a timeline much more constrained than we thought that we did. 407 is when suspect vehicle 1 was last seen, possibly parking behind 1122 King Road. So, if that's true, 4:07 a.m., parking the car, would not the perpetrator need a few seconds at least to get from the car to 1122, whatever the entry point is, which I feel, and I'm giving this a speculation, 100%, I feel the entry was on the second floor, sliding glass door. So, if that's true, we now have a much shortened timeline. 407 plus, maybe getting close to 408. 420 less, maybe somewhere around 419. We have an individual diagnosed with autism. As Yolie stated last night during our live, people with autism might not have full dexterity, might have problems with holding a weapon and using it over and over and over and over again. I don't know how this timeline works, given we now know that the soul and the correct perpetrator is autistic. And I am very, very disappointed with Ann C. Taylor and the rest of the defense team for suggesting autism is a mental psychiatric diagnosis that takes you out of being possibly subject to the DP. Autism is not that type of autism is a psychological type of evaluation. It just means you're a little different. You might come across being weird, different, but people who are autistic, some of them could find a cure for cancer because of the repetitiveness, not willing to let go of something. So to now associate autism with being the type of severe mental illness that takes you out of DP consideration, I find very offensive from the defense. 100%.
Yeah, the way that they worded that is probably not appropriate. Because that's definitely, you're right. I 100% agree with you that if that's the way they went about it, wow. They should have went about it a different way, away from this, mental illness type thing, because that's definitely not what that is.
No, it's not. And so now we have a person who is vegan, right? Autistic,
Oh,
right?
Yolie, welcome. So good to
I
see
know, Leah.
you.
So great to see you. God, can we get
Aw.
Yolie up here on panel? She's so amazing with this diagnosis.
Yeah.
So amazing.
I'll
Audrey,
get the link out.
Yolie, get up on panel, please, and discuss autism. I really love it. I'll be back, Audrey, and just.
Okay. All right, just give me a second here. Oh, I could do it right here. Here you go, Yolie. It's so good to see you. Yes, Yoli, you had such a great a view and explanation on this. If you could come up and explain that. I know we were all on Evil CJ investigations and media last night, and we had a great conversation about this. So if you have, I'll put that in the link below as well. It was a great conversation. And Yoli and Kathy were both on there with me, and of course CJ was there. We had a panel, and so yeah, we there was a lot of great things said. Okay, great. Yoli says she can get on for a few minutes. That would be amazing. Yeah, we could just explain a little bit about how you were explaining it last night. That it was just so informational. It was a great viewpoint. It was great. Very beneficial for people to
Yeah.
hear.
What I have to say is I feel people with autism have enough discrimination against them, and to now they're going to be, associated with a severe mental illness to where they need to be taken out of any consideration for the DP. I find very offensive. I really do. I would like Jolie's opinion because I feel she's an expert on this topic.
Hi, Yoli.
She has
Hi.
discussed this issue. Thanks, Jolie.
Yeah,
I'm going to shut my
no
mouth.
problem.
Give you the floor.
Yeah, I can do this for a little bit. So yeah, that motion turned a lot of people off. The death penalty motion, based on the fact that he has ASD, autism spectrum disorder, and you know, the repetitiveness. I like that point that you made, Kathy, about how someone who has ASD could possibly find a cure for cancer because
Yeah.
they're they're like obsessive compulsive. They just don't give up on certain things, and it's called perseveration. And they keep going back, and that term was used in the motion, perseveration, where they just keep going back to certain things, and you know they have insight into things, and they're not mentally ill. That's the big disappointment with that motion. And it was filed after the deadline, so it makes it seem like they're making it up, when actually I pinned him from the very beginning, that he seemed, just based on the statements about him, that he was likely someone who had a routine and wanted to keep that routine. And then when he moved to Idaho, or to Washington, when he moved to Washington, he had to find himself again. He had to find a new routine. And so I would be surprised if maybe the defense has somebody come from Pennsylvania to talk about his routines and how he would drive around at night, because we know he was up at night. He was a night owl. And we know that, he would be vacuuming uh, at night. And the neighbor talked about that, and she had a very specific recollection about it because she didn't want her baby to wake up. She had a newborn baby. And so he would be vacuuming, and she would hope that the vacuuming sound would wake up her baby. So he had, strange habits. And that's why in the alibi document, she wanted to introduce it as habit evidence because, and I haven't done the legal research, but I don't know if habit evidence can be used to corroborate along with witnesses alibi. So the way that I understood it was that Ann Taylor was going to use those people, those state witnesses who had said that he was he was his phone pinged in the cell towers close to the home 12 times within those 4 months, that he had a certain he was it was his routine, and maybe it was like every 3 weeks that he had to drive, or every 2 weeks that he just needed to drive. Like, they have strange repetitive behaviors, and they don't make sense to us, but they make the person with this disorder feel, it lessens their anxiety. They feel better. And for whatever reason, there are a lot of people who are OCD, who have obsessive compulsive disorder, and like they have to walk over, uh, they can't walk on a crack, or they can't, they just have these weird things. And OCD is a psychiatric disorder, but the autism spectrum disorder, that's just it's not, I mean, it's not a mental disease like one that would apply to, according to the Idaho statute, because I believe the Idaho statute says the R word, the mentally R, and that word is an outdated term. But I just didn't like that motion at all.
Everyone, Yoli is a very successful attorney in California. She has dealt with this issue. She's very modest, but I would like, just to, properly introduce her to this, in discussion.
Yeah,
I
thank
am
you.
very disgusted by the fact that autism could be associated with retardation,
Yeah,
or some type of a situation where an unaliver, because they're autistic. That to me is so disturbing. So everyone, we are so grateful to have Yoli on panel today. Yoli, thank you so much. I will shut
Yes,
my mouth
thank
here because I
you.
would like you to continue. Please continue.
yeah.
Yes,
So
continue.
okay, so that was my thought when that first alibi notice came out, when when Ann Taylor talked about the alibi and she filed a document. It was the habit evidence and the fact that she was going to use the state's experts to prove partially his alibi. So I was thinking that she was going to construct something to the effect that he had a routine. He was very particular. He was away from his home in Pennsylvania for the first time. I believe he always lived at home, even when he went to DeSales University, and this was his first time away from home. So he was having difficulties, and very bright, but was having difficulties because he was in a situation now where he was a teacher's assistant, and he had to deal with students, and his social skills, his interpersonal skills weren't that I mean, they were impaired. Not that he was mentally R, but just that he was eh, learning how to. It was a learning curve for him because he had to grade papers and he was getting criticism, and I believe his professor actually had him talk to the students and have the students give him criticism in front of the classroom, as a classroom project. I mean, that was probably, it probably put him over. I mean, probably made him very upset. But then he started giving well, I say coincidentally, I don't know if it was coincidental because I don't know if he did this crime or not, but after the unalivings on November 13th, he started giving everybody like 100% on their grades. Like he just flipped. Like he wasn't criticizing them or giving constructive criticism anymore. And it could just be a coincidence, because think about it. This guy's never been away from home. He's always had his mother. Uh, and so, does that make somebody want to snap and do something like this? I don't know. But I don't think so. I think that these people are sometimes gullible and they're very smart, but they're naive in certain ways. And so he could have just gotten caught up in something that he thought he was doing something else, and car was going somewhere near the area. But it's hard to tell because we have to hear what Cy Ray says about his phone pings, and those things, I mean, I have a hard time understanding all the scientific stuff, even the DNA. I understand some of it, but you know, to think that a jury's going to have to understand this, and you know, it's it's asking a lot, because the jury's going to have to rely on the experts to not only prove the case, but if the alibi is allowed, they're going to have to rely on experts for the alibi. And then if he does have this motor coordination disorder, then that's going to be, you know, experts going to have to testify about that. And apparently they did a brain scan of his brain, and so that's interesting. So all of this leads to just complications with the case and trying to prove that he did it. And at some point, when you have so many experts, so many explanations, so many things, it makes it difficult for the jury, because you know, you have to prove it beyond a reasonable doubt. So it's like when you have experts saying one thing and another, I think it's always subject to reasonable doubt, because are these experts credible? Are these experts, are they just paid to say what they're going to say, or is there something to this? And you know, I don't know, but it's just a fascinating case.
Ladies, this is Yoli Medina from California. She is a civil attorney. She
Yes.
knows what she's talking about. If you have not subscribed to her channel, please do so immediately. Yoli has
Thank you.
brought up such critically crucial points here. Yoli, you
Mhm.
indicated that people with autism, like Mr. Koberger, are susceptible. They're like, how
Yes.
put it, Audrey? How did she put it? They're gullible. I
Uh-huh.
want to hear more from Yoli regarding this point, because she has represented
Yes.
clients in
Uh-huh.
this area. We need her on the defense team immediately
Oh
in
gosh, that would be
Idaho versus Koberger case. Audrey, my opinion only,
Yes,
doesn't matter for
definitely.
much. Yoli, please continue.
okay.
Ladies and gentlemen, please subscribe to her channel, because Yoli puts out content regarding this most important case right now, bar
Yeah.
none. Forget about Reed. Forget about the Menendez brothers. It's Koberger. This is the case.
Yeah.
Yoli, I'm sorry to interrupt you.
It's okay. It's okay. So, so I handle birth injury cases and I do medical malpractice, but I've always loved criminal law. I mean, that's what I wanted to do, but it just didn't happen. And so, I represent babies or children who were injured in birth injuries. And so I've worked a lot with pediatric neurologists. And sometimes the symptoms of autism or being on the spectrum could be caused by changes in the brain during birth and during the birthing process. And you know, there are other problems like cerebral palsy, those things that happen. You know, and it depends on what part of the brain they're injured. And I've worked with pediatric neurologists, and Dr. Gabriel, Ronald Gabriel's a pediatric. Well, he's elderly now, but and he's still practicing. But he was a very well-known neurologist, pediatric neurologist who used to go around the country and testify, and he was very believable, very genuine, very intelligent. And he would always tell me, you know, these children who have these, you know, who are on the spectrum and who appear normal, and they appear and very intelligent, uh, they they are susceptible to predators, and it's not because they're dumb, it's because they're very, that the part of the brain that detects, you know, shadiness, or you know, that part of the brain that gives you that intuition that something's not right here, they don't necessarily have that ability. And it doesn't mean they're stupid, it just means that that part of the brain doesn't necessarily work properly for them.
Okay.
And it's not, and they can be brilliant at math. I mean, they can be brilliant in physics, or psychiatry. I mean, they could be brilliant, but these are the people that always get caught up in scams. And he said, you know, your client is she's gonna have to be protected from that. Is gonna have to there's a learning process that you're gonna have to teach. You know, that the school psychologists and everybody are gonna have to help this your client to not get into situations that are dangerous, because you know you could try to see like Brian Koberger trying to help the police, you know, trying to help the police in in you know solving a crime and not realizing that he's being set up. I'm not saying that that's what happened in this case, not at all. I'm just saying that that's a scenario that could happen with people who are on the spectrum, and they look sort of normal. They have certain quirks, but they're not mentally ill. Like it, you know, I know that some people think that, but it's not that kind of mental illness. It might be a slight disability that has grave consequences, and it could. I mean, this case is just fascinating all the way around. I just wish that Ann Taylor had brought this motion when she was challenging the death penalty. It would have made more sense, because now she's filed it after the deadline, and that a lot of people can think, oh, right, yeah, now she's trying to say he's autistic, and without reading or understanding that the paperwork that he's been evaluated by people. And I don't know, because you know, when the mitigation phase, they go way back to their childhood, you know, to research, and it's possible they discovered something from his childhood, or they just had him tested and he just found out that he is on the autism spectrum disorder. And for him to find out this at this stage, uh, I don't know how that would feel, but in any event, it's a very, very interesting case all the way around. And I don't know of a case where so many experts are needed to prove or disprove his innocence or guilt. You know what I mean? It's, you know, circumstantial evidence is typically, you know, you tell your kid, don't go into the cookie jar. I'm going to leave for a few minutes. Don't get any cookies. You've already had enough. And you leave and you come back and you see that your kid has crumbs, cookie crumbs on his chin, and the cookie jar is not, the lid isn't on right. Well, you can surmise, you don't need an expert to tell you that your child has been in the cookie jar. I mean, it's something that you circumstantially can determine. And so when you complicate things by having an expert explain things, the jury can get lost. They can get lost, and they can get, it's just, I get lost, for crying out loud. I mean, at one point I understood this DNA stuff, but then after a while, geez, the jury just, there's only so much that someone can absorb, you know. And can you imagine if they're sequestered? Wow, it's going to be a lot.
Attorney Yoli Medina is with us here today from California. Everyone, if you have not subscribed to her channel, please do so immediately. Yoli has brought up an incredibly important point here. I think we have a picture of Judge Stephen J. Hippler. Audrey, if we could put that up.
We do.
Yoli has brought up yet another incredibly important point here, because the motions to strike the death penalty were fall of 2025. There he is.
Mhm.
Judge Hippler is extremely task oriented. Why are you laughing, Audrey? He is task oriented.
There he is.
Do not cross his deadlines for filing certain issues. Yoli has brought up an incredibly important point. Judge Hippler set the deadline for the death penalty motions last fall, and now we see the defense bringing it up in limine. Yolie, please continue on that point.
Yeah. So she brought the death penalty motion after the deadline, and to be honest, I couldn't go through all the motion, but but I know she also asked for leave to file that motion. I don't think that I ever saw an order granting it. Uh, but I know, did the prosecution reply to that motion yet?
Not as of yet, and
Okay.
they're due tomorrow, Yolie.
Oh, tomorrow.
And
Okay.
Judge Stephen J. Hippler has not yet granted them leave to, amend the trial order regarding the DP motions. Yolie, please continue, please.
Okay. So as you see, Judge Hippler there, he doesn't look too enthused. He's trying to understand what's going on, but usually, you look at him and he's really trying, and it looks like he's bored, or I mean, I don't know. What do you guys think? I mean, he looks like he's trying to be attentive, but at some point, it just it's so complicated to prove a case that, and I understand this because look, I've had cases where I've had 18 experts on each side, okay, on birth injury cases, and so you need a OBGYN, you need doctor, you need a neonatologist, you need a pediatric neurologist, you need a life care planner, you need possibly a rehab specialist, and you need speech therapy expert, just various different types of experts that these cases are better for an arbitration where there's a judge, a retired judge or a lawyer who listens to it in an arbitration rather than a trial. Because
Ladies, 18 experts,
yeah,
18. Could we imagine? Yolie has dealt with 18 experts in her very
yeah,
successful law career.
yeah,
How
and
many experts are involved with a DP case?
well,
Ladies and gentlemen, please subscribe to Yolie's
there's
channel.
25.
Could we get that up again, Audrey, please? Oh, I'm sorry.
It's a yeah, it's a but this case what do they have, like 25 experts? Is that Does that sound right in this case?
Oh, that's right. They have at least 20. I remember hearing that it was quite a lot, a large
Yeah.
number.
Yeah. So think about that. I think about that and I think, Lord have mercy. How is this, you know, usually fact witnesses who just talk about what they saw, what they did, you know, or somebody who's had maintains the camera, they just talk about, yes, it was maintained, I had possession of it, those things. And it goes kind of quickly, and you even have, like in a car accident case, for example, you have the police officer who testifies, maybe an accident reconstructionist who talks about a little more in detail about how it happened. But when you have all these technical experts, and we're talking about technology that's new, it's not old, okay? I mean, the IgG, investigative genetic genealogy, which is not going to come in, but I feel like that door is going to be opened, and there's going to be a big fight about it, because I don't know how they're going to be able to say that the FBI told them the tip and not say what the tip was about or what it was based on. uh it's just crazy. So you have new technology with the cell phones, the cell phone pings, and maybe that's not new for us, but for someone who might not, who might be older and might not you know barely just started using a cell phone. I mean, there's a lot of people like that. and those are the people that mainly are retired, or I have no idea how the jury pool is in Boise, Idaho, or in that Ada County, but you think of the magnitude of what it's going to take to try and prove or disprove his guilt or innocence, and it's monumental. It's mind blowing that should it take this much to try to prove someone who went into the house to unalive somebody. Like in the Luigi Mangione, there are cameras everywhere. I mean, at least you can a jury can look at the images and decide for themselves whether or not it's Luigi. Now, I don't know if they're going to have experts to try to determine that as well, because the pictures aren't that clean. But you do have the Luigi Mangione with a firearm and pointing it at the CEO and shooting. So I mean, you have that. But here we don't have some ring camera showing that someone who looked like Brian Koberger went into the house at a certain time, like at 4 or whatever. In fact, everything is so confusing. You have different cars going in and out, and it's just crazy. I just don't know how. I this trial is going to be this judge is going to have to be very on top of things, and he is. I think he is, and he makes some rulings that we don't like, but like again, the Franks hearing, I don't think anybody's I mean, that's such a high burden. You basically have to have like a officer admit that they fabricated evidence or something, you know. But
We have people all over the world right now tuning into this channel, Yoli.
oh,
I would like you to talk about, please, tomorrow, the jury questionnaire
oh,
is due to
yeah,
be filed under seal to
yeah,
Judge Stephen J. Hippler. That's him right there. And we have a secret hearing coming up April 16th
mm-hmm.
per the jury questionnaire. I think people want to hear from you regarding what you think
Yeah.
about that.
Well, actually, I have had used jury questionnaires, and in fact, in one case, civil case, where a little girl, 5-year-old little girl, Jimena, she, Jimena Orozco, and she was unalived by uh, her mother's boyfriend, and social services was involved in that case, and they dropped the ball on many levels. And we used jury questionnaires to screen jurors to find out if they had any issues with SA in the past and how that would affect them as being a juror. So in this case, they're probably going to be asking very sensitive questions on the jury questionnaire. Questions regarding unalivings, things like that. But normally, those questionnaires are not available to the public. This last trial I had, that was in September, we had jury questionnaires, and those were the questionnaires were not public. So that they're generally not public, and then they're going to have that hearing to talk about the questionnaires, and I'm sure there'll be objections from both sides as to which party wants what question, and the other side may not want that question asked, and so he's going to have to decide and help the parties to get the questions they need for the jurors. And it's going to be interesting, but we won't be privy to that. But I don't know if we're going to be privy to see the jury selection. I don't know. Does anybody know?
This is a very disturbing question, in my humble opinion, that Joel, has been brought up here, because we do not know if Fort Dyer will be public And Yoli, again, please subscribe to her channel if you are not immediately done so. Yoli, could you please discuss and bring it down to like a 6-year-old level what the purpose of a jury questionnaire is?
Okay. So the jury questionnaire is designed to filter out certain jurors before they even are questioned by the attorneys. So they ask certain questions, and usually, sometimes, a lot of times, a jury consultant helps with with the questionnaire. Now, I don't know if they have a jury consultant in Brian Koberger's case, but in any event, they try to ask questions to filter out people. It's not necessarily designed to keep people in, it's designed to filter out people. People who might have a bias, people who might have had an experience like such as this, or unalivings in their family history, or who were victims who were almost unalived or were in horrible situations, like the roommates were. And so that's going to be a big issue, is the roommates. So the defense is going to want people who don't have any experience with that, uh, because and the prosecution is going to want people who have had it and who can say, well, who can sort of understand this 8-hour delay, which I don't really understand. I don't know. I need more information. But they're going to have to get jurors who are going to be best for their case. And so there's probably going to be some issues with regard to whether or not someone who's had an experience, like a traumatic, violent experience in their life, uh, to see whether or not these people could be impartial and could give a fair determination of the facts. And so that's what the jury questionnaire is designed to do. And it can be really long. It can be long because they're going to give this to the potential jury pool ahead of time to fill out. And I don't know if the jury questionnaires are going to be filled out while they're in court, or if I believe it has to be done while they're sitting there in the court. Uh, I'm not sure though, but they're gonna if it's probably gonna be lengthy, and there's gonna be questions embedded in that jury questionnaire that are gonna automatically cause the attorneys to say, no, we don't want this person. Uh, and if the parties can agree, then that person doesn't even get called. So it streamlines everything, and when you have a case like this with so much media attention, it streamlines everything so that you I mean, if they had to pick a jury just without a questionnaire, it would take a long time, especially in a publicly viewed case like this. I mean, this has to be the most public, it has to be the most media covered case. I mean, compared to a lot of other cases, and it's so technical, it's not about somebody lying and saying they didn't do it. And you know, the other thing is that makes me think about these questionnaires. They're probably going to ask questions about, uh, autism spectrum disorder as well. Uh, and you can't precondition the jury with these questionnaires. They're just questions to elicit some answer. And the main purpose is to screen out jurors and to narrow it down so that they have a jury pool they can try to work with and ask questions. And so, yeah, it's gonna be wild. It's gonna be very, very interesting to watch.
So
Here we
Yoli,
have
do
Audrey
you,
today. I'm sorry, Audrey. Audrey is
oh, go ahead.
focusing on the issue of jury questionnaires. No
Mhm.
one else is talking about this right now. They're
Mhm.
all focused on the in limine motions. We have Yoli for you a question
Mhm.
from Katrina Miller. She wants to know, based on your opinion,
Mhm.
Do you think that this jury will be sequestered? This again,
Oh, I don't.
co-murder case.
Mhm. I, that I have that same.
Uh-oh.
Did
We
we lose
lost
her?
Yoli
No.
for a second.
Yoli, call back,
No.
please, immediately.
She'll be back. Technical.
Sorry,
There she
sorry,
is.
I got
Technical
kicked
things
off.
happen all the time. Go ahead.
I know I got kicked
Oh,
off. I'm sorry.
Twizzle's in the house.
Oh,
Hi,
Welcome,
Twiz.
Twiz.
Okay, so I don't know if the jury will be sequestered. That is a good question. But when juries are sequestered, they either become friends, really close friends, or they're irritated. It's a dynamic. And this is why I like the chats in the YouTube channels, because you see how people come together on a certain issue, and so you see what you would need to do as an attorney to bring people to come to persuade people to your side. And it's kind of shady in a way, because you want the truth, but if you believe in what you're saying and it's truthful, you're gonna want people to come together and listen to you. And but when you're sequestered, you're away from your family. You're you know for someone who's alone and lives alone and doesn't have very many friends, I mean, it might be good, but at the same time, it might be bad, because they're not used to dealing with, jurors where they can't speak about the case. But so what do they talk about when they're not in when they can't deliberate on the case? So it's basically getting to know each other. I mean, if they're sequestered in a hotel, they're likely going to go eat together. I mean, a lot of people have met their significant others in a sequestered jury trial, and it's because you're together all the time. I mean, and it's hard. So I don't know what the judge will do with this case, and it's a long time.
Yes,
So,
it is true. And
uh-huh.
Judge Stephen J. Hippler is a taskmaster.
Oh
No
yeah.
doubt about it. And we welcome to many. Steve, thank you for joining us here today. Yoli, I want to ask you a question. And I'm sorry, Audrey, I jumped in. I'm so sorry. But I want to know, do you feel that they will be able to seat a jury before August 11th?
Well, I think with the jury questionnaires, they're going to be able to do that. I think so. I think so, but there could be some problems, because of the wide media attention that this case has, and so there could be some problems with getting a jury seated. But with the questionnaires, it works well. The questionnaires just make everything. I mean, like when we had the questionnaires in this case with the little girl that was unalived by the mother's boyfriend, and we had a lot of people in that jury pool that had issues or knew somebody who had issues with SA. And so, my goodness, we'd have to take them back into chambers, because the issue is whether they could be fair and impartial despite their what has occurred, like, to them. And it takes, you gotta, just because they say it doesn't mean that they mean it, or that maybe they're saying it, but when it comes to, they can't handle it. And it's in that child abuse case that I had, when they started talking about the little girl's injuries that were horrific. One juror raised her hand and was hyperventilating and said, I and then the judge, she just said, and she raised her hand, and you could tell she was hyperventilating. So the judge took her to the chambers, and to his chambers, and then dismissed her. And we had to use a alternate, and she came back for the verdict, this juror. So I would expect that there's going to be a lot of that in terms of the injuries that were, at least to Maddie and Kaylee. I don't know about Ethan and Xana's injuries. Well, Ethan, it's redacted in the PCA what his injuries were, so I don't know. That part of it is going to have to be addressed. And they might have a jury seated, and they're questioning, not seated, but they're questioning the jury, and something might come up where they have to go back in chambers with the juror. And so it takes a lot of time, but the jury questionnaires, that's why they're starting now, because you have to fine tune the questionnaires to make it effective. And then just because somebody has had an experience doesn't mean that they can't be a fair and impartial juror. If you write in your jury questionnaire, I could not be fair and impartial in this case, then why would you even bother with that person? You pretty much just dismiss them. You don't need to call them up and ask them questions, because they've already stated it in their jury questionnaire that they cannot be fair and impartial. And one of the problems is, like, on appeal, if it's found out that a juror has lied on their questionnaire, and it's found out, I think this happened in one of these, was it Scott Peterson? I don't remember. But one of the jurors had said that she did not have domestic violence in her past, and she did. And so they found out later that she did. So the other question is, if the jurors are not sequestered, and the public is able to go in the courtroom and see the jurors, is their safety going to be at issue? I mean, this is such a high profile case, and people have so many opinions, and strong opinions, that, and I mean, think about their safety. Are they going to be harassed? Or, I mean, it's really, for these long trials, it's wrought with problems. It is like the Karen Reed. I mean, I believe they were sequestered, or at least they were brought to the court in a bus, together, and that trial was really long, and they couldn't come to a conclusion. And one of the interesting things about that Karen Reed trial is that, because this could happen here in this Koberger trial, is that one of the notes that from the jury said that, we can't put aside our deeply held beliefs, or something to that effect. And it's amazing. The judge just said, okay, well, the judge should have instructed the jury and said, okay, you need to put your deeply held beliefs aside and follow the law. If you can't do that, then I'm declaring a mistrial. But she needed to clarify that to them, that their deeply held beliefs to have no business in the courtroom. And I think that, I mean, that they couldn't, even the jury instructions were confusing for them, and they couldn't come to a conclusion in that case. So a part of this jury questionnaire, I mean, it's going to have to, it's a lot of work. I mean, I don't know how Judge, he must have a lot of help, because certainly uh, John Judge could not have handled a case of this magnitude, just because it's a small town. He was drowning in it. And I bet Judge Hippler is drowning in it too. And I don't know how he's going to take that motion, regarding autism and the death penalty. I don't know if he's going to be pissed, or if he's I don't know. But anyway, that's what the jury questionnaires are designed to do. They're just designed to eliminate people so that you don't have to waste the time, in questioning them. And so I don't know whether they're going to be sequestered. And it's a big ask if they're sequestered. And you're going to have to get a mix of people that can get along. It's kind of like the chat rooms in YouTube. You get trolls. And for Ann Taylor, all she needs is one person that's a big pain in the butt, to not go with the flow, and to have reasonable doubt, and it's a hung jury.
Ladies and gentlemen, we see Judge Stephen J. Hippler. Audrey has published his photograph. Could you, Yolie, please distinguish between Judge Hippler's role as trier of law versus the jury's role as trier of fact? Thank you.
Sure.
Question.
The judge is just the judge can be a trier of fact when it comes to these motions. Like, for example, the Franks hearing, he judged the credibility of Brett Payne. Normally, that's a jury function, but that's in a trial that the jury is the trier of fact. So the judge is there to make sure to keep certain evidence out that should not be in the case, so that it's fair for both parties. And so he makes rulings on evidentiary issues. For example, if a question is asked in a way that is improper because foundation hasn't been laid yet, and it's the crazy question that the attorneys always use, like, so when did you start beating your wife? It's a question that assumes that he's beating his wife, and without any questions before that. Of course the judge is there to make sure that that doesn't happen, that the questions that you're asking, because you have to, when you're doing a trial, and let's say you're a defense attorney or whatever, you ask your questions on direct, if you're doing direct, and anticipate objections by the other side, and you have to be ready to respond to those objections so you get your question in. It's a very fast process. It's fast. It's quick. It's on the, I mean, this is why I kind of preserve my energy to do trials, because like, I won't be on social media for 2 weeks before a trial. I can't, like, I just have to focus. But the court is there just to make sure he does rulings on questions, uh, objections to questions, and just know that all of those rulings on questions and evidence, how it's presented, all those rulings can be the subject of an appeal. And also, he rules on the jury instructions that should be given or should not be given. And those decisions on the jury instructions made by the judge, those are also subject to appeal. So the judge is there to make a lot of rulings to keep control of his courtroom. He needs to keep control of the courtroom and keep control. He's a gatekeeper to keep out evidence that may be prejudicial, or not just prejudicial, but unduly prejudicial. That it's so prejudicial. And just to give you an example of what's unduly prejudicial, even though it might be somewhat relevant. I had a case where a woman had a plastic surgery, breast implants that were experimental breast implants, and she did not consent to that, and she ended up getting a bad infection. And it turned out that the doctor was abusing cocaine. He was a cocaine addict, and he was just doing all these breast surgeries. He was an ENT doctor. He wasn't even board certified plastic surgeon. He labeled himself a cosmetic surgeon. And so one of the things that the defense wanted into the case was that my client had had so many plastic surgeries in the past. She should have known better. She was just a plastic surgery queen. Well, that's unduly prejudicial to her, because just because she had previous, surgeries, plastic surgeries, that means they're putting it on her, like, well, you should have known better. So the judge excluded her prior history of plastic surgeries, and that was because it was unduly prejudicial to her. And it would have the tendency for the jury to think, well, she's just she's just continuing to get plastic surgery. It's just she must have a body body disorder where they see their body and that he's just addicted to plastic surgery. But that's not the issue. The issue was whether the doctor is going to do whether the doctor follows the standard of care. I mean, he at some point maybe he should have said you shouldn't have any more surgeries. I mean, it's just there were so many issues. But see, the judge is the one who makes sure that these types of the type of evidence that comes in is uh, fair and is necessary to prove the case. And even if it's unfair, I mean, it could be unfair because it's a truth that prejudices one side. Just because it prejudices one side is not the issue. It's whether it's unduly prejudicial. And there's case law in each state that defines unduly prejudicial, and it could differ slightly in different states. And also with criminal cases, there's the prior bad acts, whether it shows a pattern or whether it's just to show that he acted in conformity with what the crime he did. But as we know, Brian Koberg doesn't have a criminal history. Uh, he does have a history of addiction. But so that's what the judge is going to determine. He's going to make all these decisions on the fly when questions are being asked. So he has to be alert and attentive, but so as to not let anything slip. And you'll hear him say overruled, objection overruled, sustained, objection sustained, and that means that the question has to either be dropped or asked in a different way, and the witness does not answer that question. So he's going to have to be quick and on the fly, and he knows that every decision he makes could be appealed, even from objecting to or sustaining an objection. I mean, all these things can be appealed. That's why there's a court reporter there taking down everything that goes on. So he's also going to make sure that the decorum in the courtroom is appropriate. In other words, they talked about people wearing T-shirts, with, in memory of, Kaylee. And, it's, it's not, it, I mean, not to be disrespectful to the victims, but really those things are not allowed usually in court. And even in the child abuse case that I had, there was a lady who came in who was very interested in the case, and she had a shirt on, Justice for Jimena Orozco. And then another lady had another shirt that said, Hurricane Jimena is coming. And it was interesting because there was a hurricane that was coming to Florida, and it was called Jimena. And so they had these T-shirts, and the judge made them leave the courtroom and change, or I don't know what he did. But there isn't supposed to be any of that at a trial. At a hearing, I don't know. I guess it's up to the judge's discretion. But at a trial, he has to make sure that the courtroom is neutral, and not biased one way or the other, because the jurors see that. So he has a big job to do, and he has to make sure that the expert testimony is consistent with the law. It comes in and it's consistent with the law in Idaho and what they're testifying to. The other thing is the judge himself has to make sure that he does not do anything prejudicial. And it's hard because he's not watching himself, but he has to make sure that he does not show bias one way or another. And just because he's questioning someone and nitpicking at the argument doesn't mean that he's biased against that party. It means he's trying to do what, get the information from the attorneys, and it's a Socratic method. And it's when you call on, and you learn it in law school, when you call on law students on the fly. You don't know you're going to be called, and you ask them a question about a case, and you question them, you nitpick about their understanding of the case, and you play devil's advocate. And a lot of times judges will play devil's advocate, and it looks like, gosh, why are you arguing? Why are you arguing? Well, that's what it is. It's oral argument. I mean, you don't go in there, thinking you're not going to argue. You do argue. And that's the only time you can argue with the judge is when you're in oral argument, because that's what it's about. You're arguing not just with the what the judge is saying, but you're arguing with the defense counsel's position as well. And people say you should never argue with the judge. Well, no, you should never. But if the judge is inciting this argument with you on your position, well, then you have to respond in turn. I mean, it's not a nice little setting where you're just like having tea and talking about the case. And it's brutal sometimes, and the judge will be brutal. And if you haven't been subjected to it, you don't know, and it looks like he's being mean or whatever. But so the judge has a big job. That those are the roles of the judge, and the demeanor he has to have, and he has to try to set the tone for everybody, right? And so the jury is just there listening. The jury just has to understand the evidence, number one. And that's the problem with this case. It's just because, look, I'm an attorney and I do medical malpractice and I rely on experts. But when it's not a medical thing, like it's a cell phone thing or DNA, uh, you know, and then what's the other ones? What they're talking about, some AT&T records and AT advanced records, whatever they are. And
Yeah,
like
those.
yeah. And so the jury has to not only listen to the evidence but understand it, and it has to be as simple as possible, because you could lose the jury and they just might see, oh, DNA, and no, DNA was there, he did it, and they might look at it as simple as that. And so it's really, that's really what the jury's there for, is to decide whether there's enough evidence that they can understand that proves beyond a reasonable doubt that Brian Koberger did this crime. And the other thing is, there's a lot of explanations to these pieces of evidence, and the more explanations there are, it's too much explaining. uh Too much explaining. And I think, like you had asked me yesterday on CJ's show, Kathy, what I thought was the biggest uh piece of evidence the prosecution has, and I said it's the or the transfer DNA on the knife sheath. And if there are records that he bought the knife sheath, or witnesses who give a compelling explanation about how they know he bought it, then those two pieces are probably the most important for the prosecution. And the car, I don't know. There's so many white cars. I mean, I get the car. Some people might think it's the car, but the car alone, without any video showing that Brian Koberger or somebody who looks like him walked into that house, I mean, that's beyond a reasonable doubt. I mean, and even then, a jury could say, "Well, I can't tell whether that's Brian Koberger or not." I mean, reasonable doubt is beyond any reasonable doubt you could ever have. And so I see reasonable doubt in this case. Other people don't. Other people see it like a closed case. And I mean, everybody has their opinions. But the jury is going to have to look and understand and try to follow the case as much as possible, and to decide amongst themselves whether there is a reasonable doubt that he committed the crime. And if there is, then they have to acquit him. And if there isn't, if there's just no reasonable doubt, where the jury can only come to one conclusion, and one conclusion only, is that he did it, uh, then they convict him. But if you look at all the evidence right now, and we're not in trial, we don't see how it's going to be presented. But if we look at all the evidence right now, I'll just everybody has a different opinion, and maybe it'll calm down once we're in trial and we hear it. And people will say, well, you're not obligated to know what evidence they have. Well, I think we're obligated to know the process, and to know that uh, that somebody's being held behind bars for the death penalty. He has not said one word. Okay, now if people want to compare him to serial unalivers, which they might want to do, the prosecution might want to do in the trial, Judge Hippler has to be alert to that and not let that happen, because he has a certain look, but the jury shouldn't be prejudiced with that kind of nonsense, because the prosecution might want to slip in things like that, like that, the picture, the selfie, and what serial unalivers do. Well, he hasn't been deemed a serial unaliver. He hasn't even been convicted of the 4 crimes. So the judge has to be very careful of that, and the jury, because the jury can be prejudiced by that. And, it's a scary case. This is a scary case. And, the jury might just want to put somebody away because it's so scary. And they might think, well, look at Ted Bundy did it. He did it by himself, you know, and so all these things the jury has to be cognizant of, and make sure that they don't fall into that. And the judge has a role in that too, in making sure it doesn't come in. So the jury is going to be feverishly taking notes, hopefully. And if they don't understand a question or don't understand evidence, I don't know if this is a jurisdiction that allows the jurors to ask questions during the trial. I don't think it is. But if it is, then hopefully they'll ask questions. But I don't think it is that jurisdiction. I did see a trial online that had that jurisdiction where the jurors could ask questions. And it was interesting because some of the jurors asked questions that were like, oh my God, I didn't even think of that. And so that's an interesting jurisdiction to be in. I don't know if that I don't believe that that's how it is here. We'll see. But so the jury has to have an attention span and has to have stamina to listen to all this. I mean, I don't know if I could. I mean, seriously, honestly, I mean, I mean, just to try to do your job in this case as a juror is going to be hard. It's going to be hard. And if they're sequestered, it's even going to be harder, because you're either going to get along with everybody like people do in chat, or you're going to be just fighting when the time comes to deliberate. And so, God, it's not like a civil case. Like here, we need 9 out of 12, and where, as long as you have 9 people on your side, you're good. But, when you have to have a unanimous jury verdict, everybody has to be unanimous. It's very hard. I could see, I would hate that a hung jury would happen in this case. Be terrible, terrible. But so that's the role of the judge and the jury. And it's going to be a tough one. It's going to be a very tough road.
Yes, definitely going to be so tough. There's so much that goes into it that I didn't even think about. I also had one question. I know I've heard of a motion to strike. Does the prosecution and the defense get like a strike or two? And how does that work?
You mean striking jurors?
Yeah.
Oh yeah, okay. So you usually have like in California we have 6 peremptory challenges, and those are, we can strike we could, I guess, we dismiss or strike a juror just because. We don't have to give an explanation. We just thank and excuse juror number 6. After you question all the panel, the judge says, do you have any peremptories you want to use? You can say no. We take the jury just as it is. And then the defense, or in my case, it would be the defense, would say, we'd like to thank and excuse juror so-and-so. And so that juror gets excused. And then the new juror comes and you have to ask the new juror questions. And once it starts moving, it gets very strange. It gets very, you start losing track of who's who. And it's funny. It becomes funny because, oh, juror number 6, you kind of want to get, to know the jurors. And that's the only time you can ever talk to them is during the jury selection process. So you get to know them a little bit. And so you have in California, you have 6 preemptory strikes. You can strike 6 people for no reason at all. Then if you use up all your 6, then the only way that you can get a juror off is for cause. And that is where you ask a juror, can you be fair and impartial in this case, given all the circumstances in your life and everything else? And they say, I don't think I can. And then, if you were the defendant or, the plaintiff, would you want yourself on the jury? Would you want somebody like you on the jury? No, I don't think so. And then you can strike them you can ask the judge to strike for cause. And the judge may agree or disagree. I mean, that's the crazy thing. But I think if a juror were to say that, the judge would say, yeah, that's, and usually that's not done in front of, when you strike for cause, it's usually, yeah, I guess it's just for cause, but you don't talk about it. You just say you want to strike for cause. And in certain cases, sometimes the judge will take that juror back with counsel, and the judge will ask questions in the chambers. But it takes a long time. I mean, for it, I'm sure the jury questionnaires are going to weed out a lot of people. So hopefully there won't be too many challenges for cause or strikes for cause in the Koberger case.
Well, unfortunately, the public will not see the jury questionnaires of the proposed because they are filed under seal.
Yeah.
There's a big secret hearing coming up on April 16th. But I want to ask you, Yolie, is Judge Stephen J. Hippler, pictured here on the screen, has denied the state's request to have Cy Ray appear at hearing
Mm-hmm.
on in limine motions, including for the in limine motion dealing with alibi defense.
Yeah.
Has stated, Judge Hippler, that Mr. Ray's opinions could be provided via declaration, and he could be available if the judge has any, just questions
Uh-huh.
via Zoom. I want to hear your opinion, Yolie, regarding the court's denial of having Mr. Ray at hearing.
Okay. So the hearings in motions in limine, so you generally you have a piece of evidence that you either want to exclude or get a ruling on to allow it into evidence. So the piece of evidence can be put into a declaration. In other words, if it can be put in writing, it's for the judge only. So the judge can read it, and if he has questions, ask about it. So normal, I mean, I know it sounds harsh, and people are saying, "My gosh, he's not letting him speak." But normally, motions in limine, they don't have hearings like this where you get testimony, unless it's like a competency hearing where a witness has to go and uh, you know testify about whether or not they can testify, like the judge may ask them questions, about their competency, like a child or something, or, you want to get that ruling ahead of time. You don't want to put a child on the stand and then it fall apart. So, sometimes you can get witnesses, but in this case, I don't see it as a big deal. It could be, but in my opinion, I don't see it as a big deal. I see it more like it's going to be a question for the jury to decide whether or not Cy Ray can provide an alibi or has provided an alibi that he could not be at the house where the unalivings happened because of certain technical data that shows he was somewhere else. The phone in the car. So it's not terrible blow to the defense. I mean, I think part of why Ann Taylor wanted Cyree to testify is to persuade. You know, and look, the prosecution has done some things for the public to persuade the public, and Ann Taylor, she's doing some of it too, and I can't really blame her, uh, because she does have an obligation to her client, not just in court, but you know, in general, and so she's gonna want to persuade, uh, to allow Cyree to testify. But she can do that without having him testify, because really he needs to testify in trial. And the judge just needs to know what he's going to testify about and whether it's admissible under the standards for expert testimony, and whether it's admissible as for corroboration of an alibi defense. Because he is a witness, he's an expert witness, but he is a witness that could corroborate through scientific or through technology that he could not have been at the house at the time they say he was. And then, so that's what I mean. This case is going to be piecemealed. And I wouldn't, you know, I wouldn't put too much, you know, on that, oh my God, he's not being fair, or he's not, you know, he's not, you know, you know, it's one thing if it's a motion to compel, where you want answers. You want answers. You will ask questions that you don't know the answer to in a motion to compel, because that's what you're looking for. You're looking for answers. And you know, it's not a trial. It's just it's you're asking questions about where things are, because you don't know where they are. And so that was a motion to compel. When she had Payne and Mowry, she called them as witnesses. And then the DNA thing, she called witnesses because it was a motion to compel, but it's a scientific issue. So she had to educate the judge on why she needed the information she was requesting. So in that case, an expert assisted the judge in determining whether she could get the information she was requesting regarding the investigative genetic genealogy stuff. So in this case, it's a motion in limine as to whether or not Cyree can testify about his defense, about his alibi. And so, do you need testimony? No, I don't think so. But you know, again, technology is not my strong point. I would think that if the judge has questions, he's going to have them on standby and he can ask, because it's not the time for both for like, in other words, he would be testifying only for the judge. I think if he did testify in this motion in limine, because the judge has to listen to the expert and decide whether it's admissible, whether what he's going to say is admissible. And the prosecution can argue, they can argue that it's not admissible because of this, but they're not really going to get into a cross-examination with the witness on a motion in limine. So I think what the judge did was fair. He said no, but you know that Cyree, I mean, I haven't looked at that motion, but if Cyree provided an affidavit, then he's going to look at the affidavit, and they're going to present arguments on why or why not this should be excluded or included. And then if the judge has questions, he can ask Cyree. And so I think that's I think it's fair. But you know, a lot of people are upset about it, and it's because they don't. I mean, it's reasonable if you don't know, you know, how these things go. You know, you're going to think that's unfair, and it's not unreasonable to think that if you don't know how these things work. But you know, I don't see it as being unfair.
Yoli, 3 words for you.
Hmm.
3 words only. And I hate to say this because I know this is going to light a fire.
Oh,
Audrey laughing.
oh, just because.
Okay, the affidavit of probable cause, dated December 29th, 2022. Frozen shock phase. Where was that ever indicated in DM statements? Thank you.
Well, yeah, we don't have the entire transcript. See, that's the thing. We have excerpts. We have excerpts of what her statements were. So we also have narratives of what she said, and I won't go by the narratives, but I did a video on how DM was unreliable as a witness. Number one, she admitted to the cops she was drunk, and she didn't know what was going on. But that quote, I thought about it last night. That quote, "frozen shock phase," it was a quote that was presumably made by DM. So we still have to see the entire statement. See, that's the thing. We haven't seen the entire statement. Judge Hippler probably has, but she's given statements to various officers, and they each, have a transcript. So it might be somewhere in that transcript. But if it is, and he quoted it, it's just not reliable because of all the activity and the texts and the fact that they're on Instagram and all these things. uh People in a frozen shock phase are, well, just the phrase frozen, they're like frozen, so they can't do anything. I mean, that is just, I that's just my only thought process is that maybe she said it somewhere in the transcript and it's not being used in these motions. But you would think that the defense would use it to say, look, frozen shock phase, look at what they were doing. And so it could be somewhere, but certainly it does not look good. It does not. That statement there does not look good in light of what we know now. And
May I also add to the equation, because this again was a direct quote from Detective Brett Payne. Number one, frozen shock phase. Number two, clad in black. What 19-year-old uses that type of language? Thank you.
right, and especially how you see certain uh state, or you read certain statements that she made, that, like, I don't know if it was a dream, I don't know what I saw, I don't, I saw a bushy eyebrows, and then she has paintings of bushy eyebrows in her room. She saw one bushy eyebrow, she saw a vacuum cleaner, and then she saw a fireman. So it's 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 really, I determine myself that she's not a reliable witness just based on the excerpts that were put in the motions, because if she's your star witness, it's a little problematic. I mean, I don't know how clad in black. Just look, in the text, Bethany said Xana was wearing all black. They don't use, like, she didn't say Xana was clad in black. Well, I mean, clad in black. I mean, I don't even know if I knew the meaning of that word clad when I was 19.
Yes, I do.
I honestly, I don't even know if I do. So
It's so
yeah,
military. Yeah.
yeah, I
So
don't know
that,
the. Go ahead.
go ahead. You go ahead.
Oh,
Go ahead.
so I was just gonna say, it is so military. It's so, like, clad in black. It's
In
crazy.
quotations,
I know. And you
in
know
the
what? He's gonna.
affidavit of probable cause, signed by Detective Brett Payne.
But the probable
December
cause affidavit
29th,
is irrelevant. Remember, they want it to
yeah,
be irrelevant.
that is true. However, Mr. Payne stated DM said clad in black and infamously frozen shock face.
It's just those. If it's not somewhere in her statement, oh man, that's gonna be. That's going to be problematic. It's just, I mean, just based on what I know now, and I don't know everything, because there could be something that proves that Brian Koberger did it beyond a reasonable doubt. I mean, there could be, but right now it's just a big mess. I don't even know. We don't even know what kind of car it is. You need an expert to tell you what kind of car it is.
Yeah, the state has so much explaining to do, which is very
Yeah.
odd. It should be just right out in the open.
Well, let us know. I mean, the public should know if they have the right guy. I mean, if they have a video of him walking into the house, or somebody who looks like him walking into the house, at least give us some breadcrumb. I mean, I think we have a right to know that they have the the right person. I mean, it might. I mean, even the defense, if the defense wants to keep it quiet, it doesn't do anybody any good, because eventually it's going to be found out. So there's no. I mean, it just started off bad with that whole non-dissemination order. That's how it started. And I think that's why we are here where we are and dissecting the evidence or what is going to be evidence. But we'll learn on April 9th what's coming in and what's not.
Yeah, that'll be here so quickly.
So
Yeah.
why has Judge Stephen J. Hippler, you're laughing about Audrey, that's his name, Judge Stephen J. Hippler, not amended or set aside the non-dissemination order?
Well, it's confusing because he did say he wanted more. I mean, remember he did that order that's saying that, well, I'm not just going to automatically seal things. There has to be good cause and there has to be emotion, this and that. And now I keep seeing all these orders to seal. You know,
Yeah.
it's just like, I don't know. It's very confusing because some of it is public, like the pictures, the selfie of Brian, the cars that were shown in black and white, attached to exhibits, Brian's driver's license. Some things are being shown, including the partial transcripts of DM, and but other things are sealed, and so it's like, okay, so we just get to see partial stuff again. So now not everything's sealed. It's only certain things that are sealed, but it's very confusing, Kathy. It's confusing. I don't know how. I mean, especially that court session where the evidence was presented. Uh, it was the hearing where the evidence was presented. It was the IGG Franks hearing, and the evidence was presented in private, but yet the oral argument was open to the public. But how do you argue the facts when the facts were under seal, were private? So it put them, both sides, in a very strange position. And eventually the transcript of that private testimony or whatever it was became public after the fact. But that certainly didn't help the attorneys when they're arguing, because they had to watch what they say. They couldn't argue fully, and they couldn't argue fully the way they want to, with all the facts that were presented in the closed hearing, because now the oral argument is public. And I don't know why that decision was made to do it that way, and I don't think it was intentional, but it certainly hindered the argument part of it, because Ann Taylor was confused, and I was confused. I'm like, how are they gonna do this? I don't know.
Right. I think that it started out as one thing. I guess Ann Taylor wanted to put a cap on what all of the media was saying, but over the course of the case, it has morphed and changed into different things. And then now, I don't know if it's just going to stay there for formality, and Judge Hippler is just going to kind of pick and choose what he wants to stay sealed and whatnot, because don't they sort of keep respect to like what a former judge has already ruled, and so therefore maybe Hitler will keep it in place, but he kind of won't. He'll just kind of make sure that there is a lot that is unsealed, but then still seal some important things. I think it's even morphed again once it's gotten into, you know, Hitler's hands. What do you think about that, Yolie or Kathy?
Oh, great point.
Oh,
Because it's called the law of the case,
yeah.
and the defense like cited to it. But what if the law of the case is incorrect? Because every single motion and order to seal put the First Amendment in the back seat.
Mhm.
Sorry, that's what happened here. You know, we should not be sitting here 2.5 years after these horrendous crimes happened and wonder why it is that Brian C. Koberger has been arrested and charged as the only defendant. Are there other co-conspirators out there? We don't know.
It
The
just
First Amendment of the United States Constitution does not allow for these type of secret hearings and trials.
I know it bugs me. It's like, well, because it's a high profile case, but still, that should even be more. It should even be more open. But I that's just my opinion. There could be very very good reasons why Hitler's keeping certain things sealed. But here's a point that I did want to make about the law of the case. Sometimes it really isn't the law of the case. It's something like this non-dissemination order. It was to protect to protect certain witnesses from harm. And if you think about it, like the 911 call, if we had learned about all the if we had learned about all the texts between the students, the surviving roommates, and we learned about the 911 call, and you put it together, people might be very angry at the roommates and they might want to harm them. And so perhaps at the time, right when the crimes had been committed, like the first 6 months or so, maybe he wanted to keep things sealed just to protect, you know, people from getting injured or, you know, getting attacked or, you know, because people, in the heat of the moment, you know, like the crime just happened. Now that things have died down, maybe now they think that it's better to release things. But the you have to weigh the harm that it's done. You know, the very reason why they had to move to Ada County was because of all the prejudicial content out in the media. And the reason why there was all this prejudicial content out in the media is because people were speculating. And that's what people will do. They'll fill in the blanks when there's nothing there. And the very reason why that the non-dissemination order is what was causing Brian Koberger to not have a fair trial in Latah County. I mean, that's how I see it. So it did. I feel like the non-dissemination order did more harm than good. And maybe it would have worked just for a little while, just till everybody died down, everything died down, you know, people were calmer. But, you know, it's really sad.
I agree. 2.5 years later, and this non-dissemination order has not still been set aside. What was it intended to do?
Yeah.
It did more harm than good. And I want to bring out this point. It was the defense that drafted that
Yeah.
first non-dissemination. It wasn't the state of Idaho. It was
Right.
Ann Taylor. So we need to put blame on the defense for that non-dissemination, in my humble opinion. Also, the defense wanted no cameras in the courtroom at all.
Yeah.
That's Dan Taylor, not the prosecution. And it's like the First Amendment comes before everything else.
Yeah, and in
Sex
thinking,
and everything else.
yeah,
Why?
in thinking about it, it may have been because she feels, well, I don't even know why the defense would want. I'm not even sure. I don't even know what to say anymore. But I have to get off in a little bit. But here, what I wanted to say too, because I get so upset when people start talking about serial unalivers and they talk about BK being, that he would have done it again, and that this was just the beginning for him to be on a career as a serial unaliver. I just wanted to make this point because I just popped into my head right now, and I might as well say it before before I get off. It's kind of off topic, but well, the one thing I want to say is that these, and I read a lot of books about serial killers, and they are social beings. I mean, for for example, uh, the BTK unaliver, he once he got caught, he talked and 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 told the judge all about how he did it, what he did, this and that. Okay, Ted Bundy, uh, he had girlfriends. He was very social. He was in the political scene. He wanted to be a lawyer. And he also talked and talked about his innocence and talked and talked, and even served as his own attorney and so on and so forth. And then even Jeffrey Dahmer. Okay, Jeffrey Dahmer was the social person. That's how he got his the people that he unalived. I mean, he wasn't hiding and stalking people. He was out in bars and he picked up men at bars. He was social. And so just with those three, you look at BK and he's not said one word. I mean, I haven't heard him say anything unless except for the times he's being stopped by the cops. And when he says, "Yes, Your
Yeah.
Honor," or whatever. I haven't heard him say anything. Anything.
No, he stood silent.
Yeah.
Yeah.
And so how can people compare him to those unalivers? And when there is a big significant difference, in my opinion, this is just my opinion, there's a big
I
significant
agree with
difference.
you.
I mean, you can't,
Great
this
points to
this
make.
right. And I mean, I can even think of Rodney Alcala. He was the local unaliver here in Orange County, although he unalived others in other places. And I took my godson to go see the trial because he was fascinated with Dexter, and I wanted to show him what a real serial unaliver is. It's not glamorous, it's serious. So I took him, and it was here in Orange County in my area. I took him, and we watched part of the Rodney Alcala trial, and he unalived a girl in Huntington Beach. But even he was social. He was a photographer. He would talk to everybody. He started off by taking pictures of girls, and then he got caught because he was on the dating game, and he was wearing one of the earrings of one of the victims, and the mother spotted it. And he was out there social and dating, and look at Brian Koberger with his gloves in the middle of the night sorting trash. I mean, I don't I this in no way negates what these four students went through, because they did not deserve what happened to them at all. At all. And justice needs to be served, and the proper person or persons need to be held accountable. And if it is Brian Koberger, well, then so be it. But right now, I it's very confusing.
Those are great points. Absolutely. Distinction there with the personalities. It's blatant how different those personalities actually are.
Really, I mean, I mean, here we have Brian Koberger, his dad, calling someone over there and saying, he can you be his friend? We can. I mean, it's just
Oh,
Well, yeah, I mean, it's sad, but I mean, it doesn't. I don't want to diminish the victims because the victims, they are the ones. They're why we're here.
mhm.
We're not here because of Brian Koberger. We're here because four
Right.
students were unalived brutally, needlessly, and we can't even get straight answers on what happened.
So true.
But anyway, you guys, I got to
Just
get off.
don't know.
I wasn't planning on being on a panel.
Thank you so much for coming on, Yoli. It's so much fun. It's such a pleasure to have you.
Thanks,
Yeah.
Yoli.
Day.
I love you
Thank
guys. I
you.
love being on panel with you guys. Anyway,
Oh, love
okay.
you.
Okay. I'll talk to you guys later. Bye, everybody.
Bye, Yoli.
Bye. Bye,
Bye.
Yoli.
Audrey, thank you.
Yeah.
Great day. Great conversation.
Okay. Yes. So great. Great points. Yeah. Let's see
Okay,
here.
say goodbye. Thank you, Yoli. And thank you, Audrey. We'll see what happens this
Thank
week.
you.
Bye.
Yeah. Bye.